We have the privilege of hearing a dialogue between two men who have known each other since the late 1980s. John Q. Barrett, a professor of law at St. John's University and board member and fellow at the Robert H. Jackson Center, will be interviewing Theodore Olson. This year marks Professor Barrett's 11th consecutive year as a Chautauqua speaker. Thank you, John. Ted Olson has been waiting to come to Chautauqua since the fall of 2009. Scheduled to be with us last year on August 25th, Mr. Olson had to postpone his visit because a panel of judges in California very rudely scheduled a hearing the day he was to appear here. And the case was finally determined yesterday. But it's our good fortune that he was able to change his presentation from one on the Supreme Court to one on the judicial aspects of government and the common good, and to be with us today. In many ways, those two subjects cross one another. Mr. Olson served as U.S. Solicitor General in the George W. Bush administration, and he also served in the Reagan administration as Assistant Attorney General in charge of the Office of Legal Counsel in the U.S. Department of Justice. Except for these two appointments, Mr. Olson has practiced law with Gibson, Dunn, and Crutcher since 1965. He has twice received the Department of Justice's Edmund J. Randolph Award, the department's highest award for public service and leadership. Additionally, Mr. Olson was awarded the Department of Defense's highest civilian award for his advocacy in the United States court system. As one of the nation's premier appellate and United States Supreme Court advocates, Time magazine recognized him as one of the 100 most influential people in the world. Please join me in welcoming Professor Barrett and his wife Sarah back to Chautauqua, and Theodore Olson for his first visit.
Thank you. Thank you all very much. It's a great pleasure and truly an honor to be back on this platform, and as Shara mentioned, to be before a Chautauqua audience for an 11th consecutive summer. Truly, I have become a Chautauquan, and it's one of the real privileges in life to be one of us. Our topic today is part of the week's theme on applied ethics, government in the search for the common good. And of course, that's a very broad category. There are a lot of things that one could shoehorn into the common good. But among the things we have in common is our system of law, our constitutional order, our legislation, federal and state, that creates our society. And the rule of law is in the hands of each of us, but particularly perhaps in the hands of our legal profession. And truly at the top of our legal profession, in accomplishment, in talent, in breadth of experiences, is our guest today, Ted Olson. Ted, welcome to Chautauqua.
Thank you. It's a thrill to be here. Thank you. But after I arrived,
I told Ted it made sense to start fast because this is a fast crowd. So let me quote one of our leading lights, truly a brilliant man and a profound thinker, Justice Antonin Scalia. He speaks frequently in various venues, in addition to writing the sterling opinions that are his Supreme Court body of work. And when it turns to questions and answers, people often ask Justice Scalia about Bush versus Gore. Ted Olson won Bush versus Gore twice, maybe 3 times if you count obtaining the stay that ceased the recount in Florida on a Saturday afternoon. And so congratulations. My question is based on Justice Scalia's quick response. When people ask him about Bush versus Gore, he says, "Get over it." Ted, why should people who feel that 5 justices thwarted the public will, thwarted self-government in Florida, thwarted the prescribed constitutional process for electing a president, all in the name of dubious constitutional theories, I am just having fun with this. Why should those kinds of people get over it?
well, that was kind of a friendly question. You're starting, what's it going to be like half an hour from now? I think what he meant And let me correct a couple of things, or addition, and make addition. You did say that there were two Supreme Court decisions. The first time that we approached the Supreme Court with respect to a review of what had been a Florida Supreme Court decision, the Supreme Court granted the case and decided 9-0 to send it back to the Florida Supreme Court, saying, what are you doing? The Constitution gives the legislature the right to determine what the rules are for counting electoral votes in a presidential election, and you've just changed the rules. So what is going on? Then the Florida Supreme Court rendered a second decision without having answered the questions that the Supreme Court asked in the first decision. And we could tell from the briefing and from the oral argument that it was somewhat irritating to the Supreme Court that they would render a 9-0 decision asking the Florida Supreme Court to respond, particularly in this crisis that we were engaged in, and not even bother to answer the United States Supreme Court. So we petitioned a second time when another system of recounts was promulgated by the Florida Supreme Court. This time it went to the Supreme Court, and the Supreme Court did two things. It decided 7-2 that there was something fishy about counting votes, presidential election votes, differently in one county versus another county, and changing the rules at 10 o'clock in the morning after, and then 2 o'clock in the afternoon, which was what was going on. So, and then 5-4, they said the time is up under federal statutes that became a part of our constitutional system as a result of a very close election in 1876. The Supreme Court decided there's no more time to do any more recountings. That was a 5-4 decision and very, very controversial, and I can tell which side some of you are on.
And by the way, the friendliness of this question accomplished what he just did. He re-argued very powerfully President Bush's side of Bush versus Gore. You might just have converted the crowd.
I don't
Continue.
think so. And I think that Justice Scalia understands that we aren't going to convert a lot of people at this point. But that means that what I just did was recount the history of it, and you'll see from that it's 9-0 and 7-2 on the merits of what was going on with respect to the method of recounting votes. So it's 16-2, not 5-4. But the thing I think that is important, and Justice Breyer has spoken about this eloquently, and he talks about it a little bit in his recent book. The Supreme Court is a very special institution in our government and in our society, and we owe a lot to the Supreme Court. But Justice Breyer makes the point that we as the justices, the court, have been wrong from time to time. The Dred Scott decision, and he mentioned some other decisions, where the Supreme Court has gotten it wrong. And then he says, but, over time, we're doing the best we can, and we usually get it right ultimately. But we make decisions because it's our responsibility in society to call them as we see them. And all of us disagree with certain decisions of the Supreme Court. I certainly disagree with some of the ones that I've argued that haven't come out the way that I thought. But I have enormous and abiding respect for the justices of the court, all of them, and the decision-making process, however it comes out. And I think he's trying to say, we made the decision, it's a part of history now, let's move on. So whether you agree with that or not, I think that it's something that his sense of things, and I know Justice Scalia quite well as I know the other justices quite well, and they disagree passionately, especially at this time of the year when they render controversial decisions, particularly in June. And you see some very strong dissenting opinions, and there were strong dissenting opinions in the second Bush versus Gore case. But the justices came together. They're very close with one another. They respect the fact that they can disagree strongly and then come back together as a court the next day or the next month or the next year. And maybe a little of that is what Justice Scalia was trying to communicate. And I know I haven't convinced you, but I'm trying.
Well put. Let me stay in the Bush versus Gore area, but
can't you move on? Get over it, John.
I do want to turn to the advocate and your perspective on taking on a representation. If the highly classified Olson cell phone number had fallen into Al Gore's hands on that Tuesday becoming Wednesday in November of 2000 in Nashville, and he had called you and asked you to represent him, as obviously instead Governor Bush did, would you have been willing to be the lawyer on the other side of all the battles and litigation that became what we call Bush versus Gore?
I think I probably would. I mean, I think that I have represented clients where I've agreed or disagreed with the positions, points of view. I represented, as you know, a convicted Israeli spy. I've represented members of the a political party that I'm not a member of on numerous occasions. And I think as a I would have been honored by the fact that he would have called me. He's a person that I have great respect for. I have great respect for the lawyers that were representing him in that case. And he had very respectable arguments to make. We didn't know it was going to the Supreme Court that soon. But yes, I think I would have, and I've been honored to do it. And I think it would have been irrespective of one's political party. And I think that's one of the things that's important in our judicial system. Now, lawyers have a choice. They don't always have to represent someone. They can turn a case down if they would not be happy about winning a case for a client that they tried to win. But our job was to represent our client, which was the people of the United States, the Congress of the United States, and to see that the Supreme Court, this system doesn't work if the Supreme Court does not get skilled, passionate advocacy hopefully at the highest level. And the Supreme Court justices will all tell you, we want good lawyers in the Supreme Court arguing on both sides till we can decide from the best arguments which are the ones that we agree with. So I think it's hard to say go back, but I suspect I would not have had a problem at all.